Hello, I am Michael Brown, an attorney at DBG Law Partner. I'm going to talk about 10 things to consider if you are approached with a severance agreement from your employer. Please keep in mind that this is not legal advice. If you want legal advice about your situation, you need, of course, to speak directly to an attorney about the specifics of what's going on. The first thing to consider if you're approached with a severance agreement is to consider listening. Commonly, people will, when hearing news of a job termination or severance terms, they feel the need to discuss their perspective of things, their version of the facts, why something is unfair, and so on. It's a better opportunity to listen, to not speak up too much about what's happening so you can understand what's happening. Then later you probably will be given time to think about things, to evaluate further, and then to talk at a later date when you have better information at hand. So listening is the first thing I would recommend because it is not intuitive. The second thing to consider is that severance agreements often are not required. There are some exceptions where an employer will have a contract with an employee or will have a written severance plan in a handbook or policy, for example, but that's the exception, not the rule. So chances are if you've received a severance agreement, it may not be required. So keep that in mind that it may seem unfair, but it probably is a voluntary act on the part of the employer to offer the severance that's being offered. All the more reason to give thought to what's offered before you make a knee-jerk response to its fairness or to jump into negotiations on the spot and so on. A third thing to consider is to be mindful of deadlines that may apply. Often that's made explicit in the severance agreement itself. It will commonly have a 21-day or 45-day deadline. 21-day period is usually required by law of an employer if an employee receiving a severance agreement is over the age of 40 or over, I should say. So you should be mindful of whatever deadline may apply. If by chance you're not clear about a deadline that applies, you certainly could contact the employer, preferably by email or some means where you can keep a copy of that inquiry, but to get confirmation from them what your deadline is to respond or to sign the severance agreement. A fourth thing to consider with a severance agreement is to decide if the financial terms in the severance, and by financial, of course I mean severance payment or payments to you, as well as any benefits such as health insurance, etc. But to decide whether those financial terms are acceptable, whether you could live with those terms or not. Sounds simple, and maybe it is, but if you are to enter into negotiations, you're taking some level of risk that whatever is on the table may be pulled back from you or taken away altogether. So you first have to get an idea of what your bottom line financial needs are before you take further action. A fifth thing to consider with a severance is to learn your leverage. And often workers misdiagnose their own potential legal claims or their own sources of leverage in negotiations with the employer. Sometimes there is no leverage, but the worker thinks that they have leverage. Other times there's in fact great leverage or potential legal claims, but the worker at issue does not know of those claims or is thinking of other claims than claims that in fact the employer might actually be worried about or an attorney might assess as being valid legal claims. So to learn your leverage, I would first say the internet is usually not a good source of information. You can get a great general idea of a million ideas on the internet, but more often than not, people will use information on the internet, such as EEOC's website, state websites for discrimination issues, for example, message boards, and so on. People often zero in on information and that's wrong for their situation, or they will not understand how that information is applied in the real world legal system. So often it can do more harm than good to act upon information that you find on the internet. Now with that said, looking on the internet, looking around at attorney websites, blogs, and so on, can give you an idea of what potential issues are in play and to help you ask more informed questions if you in fact speak with an attorney. But if you're looking into legal leverage, I would definitely recommend speaking with an attorney. Whether or not it's me, I think you should speak to an attorney before you negotiate or attempt to negotiate based on legal leverage. But something else to keep in mind is you may have practical leverage. There may be people involved with the decision to terminate your employment or offer you a severance agreement who did not agree with that decision, but are merely going along with someone else's orders. They may be sympathetic to your situation. They may feel themselves that the offer was unfair. And there are many factors that could potentially help you increase a severance offer. So, not all of which are legal, some very practical. But the main thing is to try to understand all those factors before you enter into any sort of negotiation. The next thing, point 6, that I would say to consider if you're presented with a severance agreement is to learn the terms and understand what they mean. And terms, of course, meaning the terms of the written severance agreement. Some terms are pretty obvious and straightforward, such as return of equipment or things that are very spelled out and itemized as to what to do and the specific items or terms involved, and they're understandable. Other concepts can be obscure and have legalese, but an attorney may tell you, hey, they don't matter a lot. Other terms that have legalese, an attorney may think does matter. Common terms of a severance that can be problematic for workers are terms involving non-competition, certain confidentiality terms, things that can affect employment going forward. Another important term of a severance is the waiver of potential legal claims or actual legal claims and all the potential claims that waiver may apply to. And so on. I mean, there can be one-sided penalties within a severance agreement that can have severe consequences if you were to breach that agreement. So, just to make sure, it's important to make sure you understand the terms of the severance agreement before you make a decision about signing the severance agreement or negotiating about the severance agreement. A seventh point to keep in mind or factor when you're presented with a severance agreement is to not threaten the employer. And by threaten, I mean every sense of the word, whether it's a mere suggestion that you may see an attorney about potential legal claims, even a request for your employee file, believe it or not, will be construed by most employers to be a threat in response to a severance agreement. Most employers will assume, given that context, that you're preparing for a potential legal claim, and that's why you want a copy of your employee file. So you just want to be very mindful of your actions and whether they may be perceived as a threat. If you're intending to convey a threat by saying you'll talk to an attorney, or you think you have a legal claim under discrimination law or a different law, for example, any of those threats that you articulate on your own without the advice of an attorney are more likely to backfire than to help your situation. And I say that because most employers are familiar with the drill, so to speak, of a legal claim, or they are in close contact with an attorney after a short while, and that attorney will be familiar with the process involved and with the evaluation involved with legal claims. And so if you off the cuff make a statement based on an assumption that you have a legal claim or that you have leverage, especially if you don't have an attorney involved with that, there's a problem in that the employer won't view it as a credible threat of litigation, for example. But even more problematic is if you misdiagnose a potential legal claim, the employer will react negatively in most cases, and it will set you back. So don't make threats when presented with a severance agreement. If an attorney assesses you to have a potential legal claim, then of course you could decide whether or not to approach the employer with that attorney's advice in mind, or along with that attorney contacting the employer for you. An eighth factor to consider with a severance agreement is if you enter into negotiations with a severance or about the severance with the employer, keep your language factual and polite. There is no good that comes from using personalized terms or adjectives such as unfair, lie, etc. Those types of terms usually set negotiations back. They don't appeal to your audience, being your opposing party who you're negotiating with. And so it's more influential and also more cordial if your communications focus on the factual content. For example, if an attorney assesses you to have a potential legal claim, then that attorney may convey to the employer the facts, the events, who said what, who did what, in straight factual terms that support a discrimination claim, and talk about the law aside from those facts. Attorneys are often good at, sometimes not, but more often than not, they're good at communicating potential legal claims the right way, and also in a constructive way to hopefully negotiate rather than alienate the employer. And if an employer is alienated by polite and factual talk about valid potential legal claims, then it could be that the next logical step is litigation. So that's certainly a possibility, but if you have an opportunity for negotiation, you certainly would first want to see whether that's a possibility, whether it can be resolved. But if not, there is the option for potential litigation. A ninth factor to consider when presented with a severance agreement is, if you get an attorney, or you're considering getting an attorney to help you, consider the issue of the value of the potential assistance, whether you feel the severance agreement or potential result from litigation can be significantly better than the terms of the severance you've been offered. You want to consider whatever the potential value is versus the potential cost of that attorney's fees. Any attorney you speak to should be able to assess for you an either exact dollar amount or a range, an estimate of legal fees for various things, such as a period of negotiations, or drafting a legal complaint, or litigation from beginning to end of a discrimination complaint, for example. Attorneys that are familiar with this process should be able to give a budget and also talk about different types of potential legal fees, including a straight hourly fee, or a flat fee where it's a one-time fee that you're certain is covering all the services at issue, or if it's a contingency fee where you're only paying a percentage of whatever recovery you have if you successfully settle or win a litigation. So you want to have clarity if you talk to an attorney about what the potential legal fees are and the costs of legal fees and other costs versus the potential benefit of what's at issue. Now the 10th point I would say to keep in mind when presented with a severance agreement is that you should set a goal or an ideal in mind of what you intend to accomplish. If you're upset when initially receiving a severance, that can cloud one's judgment as to what they are seeking to achieve. But always keep in mind that there has to be an end result of whatever process you undertake, whether it's negotiation or whether it's litigation. At the end of the day, there's going to be a result, there's going to be a winner and a loser, or there's going to be a settlement, and any of those scenarios involves an investment of time, potentially an investment of money, potentially a receipt of money from the other side, and so on. And you want to have an informed assessment of what range of outcomes is possible, and what you think your ideal acceptable result is, your ideal bottom line, and so on. But keep a goal in mind. If it's a range or an estimate, that's fine, but if it's totally abstract what you want, you'll never achieve it, and you could find yourself acting out of emotion or a sense of unfairness rather than a sense of improving the financial situation as presented to you when you lost your job and were presented with the severance agreement initially. I hope this has been helpful, these 10 factors regarding a severance agreement. Again, my name is Michael Brown of DVG Law Partner.